Good afternoon, everyone. It's 5 o'clock on Tuesday, December 5th, 2023. I'd like to call to order the meeting of the St. Croix County Board of Supervisors. Our invocation was to be given by Tim Sackett, but Tim is not able to join us today. So if you'd stand and join me in a moment of silence, I would appreciate it. As for our roll call, rather than do it individually, I just want to mention that Supervisor Lind, Anderson, and Hanson are excused. Everyone else is present with the exception of Supervisor Fiedler, who I believe intended on joining us via Zoom. He's not quite here yet. Okay, let's move on to public comment. I'd like to ask Denise Sinclair Todd first, and please limit your comments to 3 minutes. Thank you.
Okay. Yep, please go to my podium.
Thank you for your time. My name is Denise Sinclair Todd, and I'm a longtime resident of St. Croix County. Grew up in the property on Somerset. It started in 1964. My family's owned the property since 1964. And I apologize for the last meeting. No one represented our family because somebody was an hour late. So they were an hour late. They got the meeting time wrong. So excuse me for not being there. But just talking for the Sinclair family, when we sold the Apple River Hideaway, we want Michael Cappers, of course, to succeed. He's been very good to us. But we sold the property to be a concession stand and an off-sale liquor area, and to be open only during the day and night. Obviously, we didn't want a huge concert venue or a large bar next to our property. And we're very concerned about the loud music that carries down the river. And our real concern is that it would affect the market value of the neighboring real estate, which is our property that we've owned since 1964. Thank you.
Thank you. Frank Plord.
Yes, my name is Frank Plord, and my family and I have property that is adjacent to the Cappers property on the north side of the river and is impacted by their operation as well as Sinclair's. And in a previous meeting in May, I believe, we had a handout identifying the concerns we had with the rezoning issue in this case. And I have copies of that that was submitted then if you need that for refreshment. But there were 8 items that we were concerned about. And one of the biggest one that Denise just raised was the inability to have any issues be controlled by the township from the standpoint of noise or other activities that will tend to make it less attractive to live on the other side of the river near the campground. So the key is, I think, if the board votes to appeal the judge's decision, at least there's some time to find a solution that would be workable for Mike Cappers, as well as give us the protection with a conditional use that the conditional use permitting process does. Thank you.
Thank you, Frank. Any other public comment? Anyone else from the public like to address the board? Any other public comment? Okay, thank you. We'll move on to the consent agenda. Do we have a motion to approve the consent agenda? Supervisor Osnes, second to Supervisor Burning. I believe that we can probably use a voice vote with this. All those in favor of approving the consent agenda signify by saying aye.
Aye.
Any opposed? Thank you. That passes unanimously. We'll move on to the county administrator's report. Ken?
Thank you, Chair Long. The financial report is in your packet. If you have any specific questions on it, I'd be happy to answer it. Overall, the financials are looking very good for where we are at this time of year, getting close to the end, and I think everyone's going to be pretty much on target for their budgets. I did want to point out just a couple of additional items then related to the government center project specifically, as we're nearing the completion of the north side. So it's the side over here on this side of the building. That's the north. The project is going to be wrapping up there in the next probably 4 or 5 weeks. So we'll have occupancy by January 15th in that. So that's the lower level is the facilities department. This level, the ground level, is going to be the jury orientation room. And then the second floor is the child support. Although we're going to be moving the sheriff's office into that temporarily during the construction, sort of phasing and moving people around so they can get that part down there remodeled. As far as budget for the government center project, then we've had a couple of things that have come up. We're down to $2,990,000 and some change, so just under $3 million left in the contingency on the project. The two big things was one was HVAC controls. There was basically an error in the way the architect had designed it. We had to make some changes to that. And then the big one was the generator. We'd originally planned on not replacing the generator, but really as we got further into it, they determined it was going to have to be replaced. So those are the two big things that have gone into the contingency. At this point, you know, with all the new construction going on, we really don't anticipate any additional new construction items. Those were sort of some front-end items we had. So the $3 million that we have left will be used on the remodel side. That's really where we thought we'd have a potential more exposure to change orders coming in on remodeling. Supervisor Fiedler has joined us now, by the way, Chair. So that's where we're at on the government center project, but I know everyone's looking forward to moving into that the new facility on the north side here. Any questions on the financial report or on the project, I guess?
Okay, we'll move on. We've had a request to rearrange the agenda slightly and move the annual department reports up ahead of the business items, the two business items. So I'd like to move ahead with the annual department reports, judicial circuit court judges, family court commissioner, and register and probate. Who's first?
Lucky Judge Waterman.
Thank you, Mr. Chairman. Tonight I bring you the court's annual report. I speak on behalf of my colleagues, Judges Needham, Vlack, and Nordstrand, your members of the third branch of state government. The Wisconsin court system exists to protect individuals' rights, privileges, and liberties, to maintain the rule of law, and to provide a forum for the resolution of disputes that is fair, independent, and effective. The courts have a unique relationship with our partners in state and local government. It is a relationship that is based on mutual respect, with an understanding that although we have very different responsibilities, we share the same common goal of serving the people of our great community. We judges recognize the challenging tasks that beset you, the county board, and we value your professionalism and leadership in overcoming and facing those challenges. Judge Needham intended to be here tonight, but he developed a scheduling conflict that he wasn't able to resolve, so I am standing in his place. You may have heard that he is running for another term as judge. To borrow a line from Mark Twain, the rumors of his retirement have been greatly exaggerated. This will be his 6th term, which is remarkable. In August, he'll celebrate 30 years on the bench. Judge Vlack isn't too far behind. He's at 22 years and still counting. When I was a lawyer, I practiced in front of both of those judges. I I now serve alongside them, and I can candidly say they are both excellent jurists, and we are lucky to have them in our county. Over the past year, the courts have been very busy. Criminal cases constitute the bulk of our docket. Criminal cases frequently spawn other cases, frequently child protection cases, restraining orders, even divorce cases, mental health commitments. In 2022, more than 2,000 criminal cases were initiated. This year, we are on pace to match those numbers. Since the pandemic, we have seen more violent crimes than normal. There have been multiple stabbings in Hudson and New Richmond. There have been fatal gun crimes in New Richmond and River Falls. Deputy Katie Lysing was lost in the line of duty in Glenwood City. In September, I handled a 2-week homicide trial. I start another in April, another one in June. Our community is very safe, but we cannot overlook the reality that serious and sometimes violent crimes do happen in our community. Fortunately, those are rare. The most common condition we judges see in the courtroom involves substance abuse. The majority of people in criminal court have significant substance use disorders. For the chemically addicted, jail is not an effective deterrent. In fact, for some, it's actually a respite, because in the jail, it's hard to get drugs and alcohol. To make meaningful life changes, the chemically addicted people need help. They need treatment. And without treatment, they're likely to return to court with new charges, and many of them do. The second most common condition we see in courts is mental health disorders. And like the chemically addicted, they too appear in large numbers in criminal court, which was never intended to be a place to treat mental illness. In most severe cases, the mentally ill are incompetent to stand trial. They lack the competency to understand the charges against them or assist in their defense. So we judges will send them to the Mendota Mental Health Institute. There they receive treatment, they're restored to competency, and they come back to St. Croix County to face trial. But more often than not, they stop taking their medications, they stop the treatment, they decompensate, and then the cycle continues. This is a statewide problem. Actually, mental health ranked as the #1 issue of importance in a critical issue survey by all Wisconsin judges. So we're not unique here in St. Croix County. In fact, in the spring, I accompanied Sheriff Knudsen, Dr. Phil Golly from Justice Services, Bob Rarrett and Char Lopez from DHS, Chief Gordon Young from River Falls Police Department at a statewide symposium about mental health. Nearly half of the counties in the state sent delegations to attend. We left the symposium knowing that there are no simple solutions, but there are things that we can do here at the local level to ethically treat mental health and keep them out of the criminal justice system. I mentioned substance abuse and mental health tonight to keep those topics at the forefront. We judges ask that when you convene your subcommittees and meet with department leaders, keep those topics in mind. But understand that by the time somebody reaches the court system in a criminal justice setting, our options as judges are few and far between. In those situations where we can order somebody into treatment or a therapeutic setting, frequently those services are not available in our community. When they are, they're burdened by long waiting lists and sometimes departments that are short-staffed. Now, before I finish, I want to invite all of you to see for yourselves the work and the business of the courts. Judge Needham likes to call it a ride-along, where you sit alongside a judge on the bench and you see what we do and the issues that we face. For those of you who want something more discreet, we can find you a seat in the audience. But the point is, we're open. We are here to do the people's business, and we encourage you to come and see what we do and learn more. Thank you for this opportunity to speak. I know that Judge Vlack has a few comments of his own, so I'll yield to him, and then I'll be happy to answer any questions that you may have.
I didn't realize Judge Vlack had a few comments of his own until about that. Do you really want me standing up here? So, first of all, I want to thank Mr. Witt and the county board We did some meetings last spring and last fall regarding the construction, and I'm lucky. I get to see what's going on every single day. And I just want to say thank you for doing it right. And you know exactly what I mean. The other thing I want to mention is that when I walk in here, I always look at everybody's hair color. And you can probably figure out why. And I, sometimes want to say, how many of you were born after 1974? Because that's when I came to Hudson. And next summer, I'll be 50 years. And I've loved every minute. I've been very, very lucky. And I served as your family court commissioner from 1988 till 2001, when I became a judge and judge since then. I'm the luckiest man in the world, or the universe. I love it. But my term ends in July of 2025. I would like to stick around, but I think it's time to step down, and that's what I'll be doing. And I haven't announced that publicly, but I just did. And I'm sure some people think it's about time, but no, this is a public service. And I've often talked to Mr. Witt and said, you've got all these departments, you're juggling these balls every single day. How do you do? And a few county board members. You don't have to answer this question. How many do you feel like at times you're getting pulled strings all different directions? And, I don't know how you do it, but I would encourage this, as what Judge Waterman said, this ride along, whatever you want to call it. I know some of you do get into the bowels of what's going on in the county, and I commend you for doing that. There's a lot of people that work in the county that are in the trenches. I often talk to law enforcement and other attorneys saying, the public really doesn't have an idea what's going on. And that's probably a good thing, because there's a lot of things that we see that, A, we can't tell you, and it's probably good you don't know. But I want to thank Judge Waterman. He's been just a key member of the judiciary when he started. I want to thank Judge Norcia and especially Judge Needham. He's been a leader since day one. And I feel very lucky to serve with them as one of the judges in this county. I want to say one last thing. And only one last thing. You get pulled in a lot of directions. Kids do not have anybody to lobby for them. I want to thank you for the money you gave to the CASA program. There's a lot of things that you don't know about, you can't be told about. Some people sometimes try to tell you about, but they need your help. I read an article this morning, my last word, and it said, students, as a result of the pandemic, have gone backwards. My concern is that from a public point of view, we are seeing the tip of the iceberg of what happened as a result of the pandemic. And I would just recommend, whatever you can do to be proactive, my concern is that if you think social services is inundated now, I'm really concerned about 2, 3, 4 years down the road. So, and again, I know you're struggling. You're thinking, how can we do all this? I don't know. But that's why you're county board members and I'm a judge. However, I'm concerned about that. But again, I want to thank you all very much. It's been a pleasure working with you. And I'm afraid you got me another year and a half. But thank you very much.
Any questions before we keep moving? Oh.
No questions for and how long did you say Judge Needham is 28?
30 years.
So I ran against Judge Needham in that election in the primary along with maybe 6 other attorneys. And I can tell you that the voters of St. Croix County did the right thing when they elected Judge Needham. He is an amazing judge and will continue to be, I believe. And I can also tell you that if you really want to get a good eye view of the construction on the north side, you should come to my office because it looks right off. And to see these guys up on the scaffold putting windows in now, but you know how much they get paid, so that's an amazing job that they have, and they've been lucky with the weather that we've had. I'm Steve Dunlap. I'm the family court commissioner, and when Judge Vlack was elected judge, I was asked to be the family court commissioner. And Judge Vlack was actually family court commissioner for Pierce and St. Croix. And when he became judge, I became the court commissioner here in St. Croix County. When Judge says that the kids are going to need some help, I can tell you from firsthand that my job is all about the kids and the parents that raise the kids. If parents could talk, if parents could use their common sense, if parents could cooperate with each other, the kids would be so much better off. I ordered parents to go to mediation over 140 times this year so far. And they follow that order. They go to mediation, and sometimes I get an agreement, and most of the time I get an agreement. But sometimes I get the mediation letter that says they mediated and they resolved no issues and no agreements were made. And I know that those are the cases that I will have 1, 2, 3, 4, 5 hearings on before they get divorced or before the final agreement and after. And that's what I do. And I can only thank you as the county board for supporting my office, for giving us the resources, the money for the mediation, and to help us. I have an assistant, Brenda, who's been with the county for a long time, does a fabulous job. But I do invite you to come and sit in my office and watch the construction, or come into my court and see the conflict that doesn't always exist. But unfortunately, the hearings that I have most of the time are the ones that the parents just don't understand. They just don't get how their actions affect their kids. And I tell them, every time you argue in front of your children, in my opinion, you're abusing your kids. And so I will try everything I can. A case that I had today, 15-year-old boy refuses to go and see his mom. And why? So I have to appoint a guardian ad litem, an attorney to represent what's best for this child, 15 years old. We have 3 more years to maybe fix that relationship. And guardian ad litems are not cheap. My policy, our policy here, is that each parent has to originally deposit $2,000. And I tell them, that's just, if you want to do it, it's going to cost more than that. And a lot of times, one of the parents, they don't have the money, and it's hard. It stresses everybody out. But we get through it. And one of the things that you don't have any control over, I don't have any control over. But the therapist, we just don't have the family therapist, the therapists out there to help these kids and help these families. I had this 15-year-old child trying to get into reunification therapy for 6 months. It hurts. So what we can do, but that's not a real good report, but that's my report. Thank you.
Any questions for Steve? All right.
I always get so nervous. I know. Well, good evening, supervisors. My name is Rebecca Rowan. I'm the Register in Probate and Clerk of Juvenile Court. As I prepared for my presentation this year, I wanted to go beyond the typical information that you're provided, maybe with graphs, statistics, and figures covering things like budgets and department achievements. As you know, it is the top priority in the Register and Probate Office to serve the public while providing the highest standard of customer service. I consider it an honor to serve our community. But what does that really look like? What exactly does our office do? The best way for me to illustrate our duties is by telling you a story, and I challenged myself to incorporate each of the 10 case types that we handle into the narrative. But first, a disclaimer. Due to confidentiality rules, it behooves me to state the following story is a work of fiction, and any resemblance to actual persons, living or dead, or actual events is purely coincidental. Bear with me. Our story begins with an infant named Rudy whose parents, Vixie and Blitz, struggle with addiction and are unable to provide for his basic needs. Rudy's removed from his home. At this first step, our office has opened a temporary physical custody case, worked quickly to set an emergency hearing within 48 hours of Rudy's removal, and made sure that Rudy's best interests are represented by a guardian ad litem. We send all the necessary documents to the judge, clerk the hearing, and process the court orders after the judge has reviewed and signed. Unfortunately, Rudy's parents continue to play reindeer games, and now a petition alleging that Rudy is a child in need of protection or services is filed, and we open another case, set another hearing, adhering to strict deadlines. We monitor the court record as the case goes through a progression of hearings. We set dates and sometimes reset dates, and we make sure the family has proper notice. We make many calls to find and coordinate with an attorney if the court appoints one for the parents. We solve technical issues with access to the case, we docket case filings, manage and track proposed orders, and set more dates and clerk more hearings. Until one day, a judge determines that Rudy's best chance to achieve permanence is to appoint a guardian so that a responsible adult can care for him as he starts school. At this point, our staff has watched young Rudy grow from a toddler to a kiddo, and we continue to interact with his mother, Vixie, as she calls frequently, asking what she can do to get Rudy back. Vixie is treated equally by every employee, and with respect and courtesy, even if she is crying or raising her voice, expressing frustration with the situation. Court staff knows not to take this behavior personally. As time goes on, she pays her court-appointed attorney bills, she gets a good job, and is successful in her treatment. She continues to contact the office frequently, and staff provides her with procedural information, not legal advice, to answer her questions at every step of the way. After Vixie terminates the guardianship, more paperwork, more hearings, Rudy is returned to her home to live with her and her new significant other, Don. Don and Vixie get married. And when Rudy starts high school, he wants to have the same last name as his parents on his football jersey. So Vixie decides to file a petition to terminate Rudy's father's parental rights. Vixie comes to the office, and court staff are stunned to see a drastic change in her appearance, for the better. Staff reviews guidelines for pro se filers and gives her instructions about complicated court procedures, such as the importance of providing notice to the biological father and having a statutory basis for her request. At the hearing, the clerk helps coordinate the father's Zoom appearance and onto the adoption. Adoption hearings are the most celebrated proceedings in the courthouse, and the clerk has made sure that family and friends feel welcome and get all their questions answered. The clerk will help the parents complete vital statistics paperwork and the paperwork to get Rudy a new birth certificate. When Rudy gets into a fight after a football game and a juvenile delinquency is filed, the clerk processes the paperwork, and now that Rudy is older, the public defender's office is notified, so Rudy has representation at the plea hearing. The clerk may help Vixie and Rudy know what courtroom to go to, what to expect at the hearing, and find and introduce Rudy to his attorney. Rudy's school is notified, and when the case resolves, the clerk makes sure that the school is informed of the length of time that Rudy is on supervision with a youth justice worker. As a result of the fight, the other child's parents files a request for a temporary restraining order. And that petition is a top priority for the clerk, and they move quickly to find a judge or commissioner to review the request. When an order is signed, the clerk makes copies and works with the sheriff's office to get the family served within 24 hours of the hearing. The clerk makes many phone calls to the parents to get missing information, and sometimes parents call and want to reschedule hearings. The clerk will give instructions, and then once we get approval, draft another order. In this case, ultimately, after spending hours coordinating the hearing, the request is dismissed. So the clerk prepares a new order and makes sure that the sheriff's office is updated because that law enforcement database has to be correct. Now, to continue the story, after years of struggling with addiction, Vixie's health suffers and she's placed on an emergency detention while Rudy's in college. When Corporation Counsel files the paperwork for a mental commitment, the clerk must find time in the court calendar within 72 hours and coordinate a hearing with the public defender's office and give Vixie an attorney in the Madison area where she's in the hospital. The hospital also has limited availability for staff to help with the video conference, so communication to coordinate this hearing takes all day. But ultimately, Vixie's commitment is converted to an adult guardianship, which is not a frequent proceeding. So the clerk's got to review a procedural manager to make sure both the mental commitment and guardianship records are accurate because there's no room for errors in the court record. Now, Rudy serves as Vixie's guardian and has many questions about his powers as guardian and how to report his mother's financial assets. Rudy is overwhelmed and scared, and because he's never done anything like this before, totally confused. Staff takes time to teach Rudy what the rules are, give him the forms he'll need, and somehow try to distill very complicated information down into baby steps that Rudy can handle. Staff shares tips that have worked for other guardians and shows Rudy how to balance an annual account using the calculator on his phone. We have one case type left. Sadly, Vixie succumbs to her illness, and Rudy probates her estate with the help of a competent attorney. Phew. The purpose of this story, while lighthearted in spirit, is to illustrate the immeasurable and often invisible contributions of the register and probate staff. The narrative skims over the very real dark underbelly of the cases we handle. Consistent exposure to disturbing stories and images may take a toll on a clerk's mental health or trigger PTSD symptoms. It's a regular occurrence to us to experience a situation where our time is not our own. Emergencies arise where staff have no choice but to work late and perhaps miss their own child's practice after school so that another child's parent can spend time with them after school because the court signed an important order. It's my hope that the fictional and very real examples of our work demonstrate how we take our responsibility to the St. Croix County Circuit Court and our community very seriously. Thank you for the opportunity to address you this evening.
Thank you, Rebecca. Any questions? Okay, seeing none, we're going to move on to our business items. And the first business item is consideration of appealing judicial decision granting Cappers a rezoning request in the town of Somerset. Excuse me. So first, I'd like to entertain a motion to appeal the zoning decision. Supervisor Osnes, motion, and we need a second on this.
I'll second for discussion.
A second for Supervisor Counter. I'm going to turn it over to County Administrator for a little background.
Thank you, Chair Long. I'll give you the non-legal version, then you can ask all the legal questions of Corporation Counsel. So this summer, the rezoning petition had come before on the Capper's property up in Somerset. So typically a majority vote would be enough to approve rezoning. In this case, there was a petition filed by adjacent property owners, which by law changed that vote requirement to a supermajority vote. It required a 3/4 majority vote. When the county board voted on it, it was 11-6. did not meet the vote requirement for the supermajority vote, so the rezoning petition was denied. That was then appealed to Circuit Court. Judge Nordstrand heard that case, and based upon his legal opinion and determination, before you then is the ability to appeal that decision. So really his decision was that he declared that the property is rezoned. And how he did that was he looked at the vote that the county board took, and for those that voted no, those 6 that voted no, he says, well, I don't think that you articulated your reason for voting no well enough, so I'm changing your votes to yes votes. All right, now there's enough votes, it's approved. So that's what was done. It's a legislative function, not a judicial function, which has different standards, and that's where we think the judge didn't apply the correct interpretation of the law. We think we would be successful on an appeal. Now, with all of that said, the net result is the property was rezoned, which a majority of the county board had voted to do. There are a number of other avenues the property owner can take to get to the same point and still have the property rezoned. So I don't know that filing the appeal is the right thing. Those are the things that you need to weigh. If you want to file the appeal, Heather will be successful. If you just want the property to be rezoned, let's not file the appeal. And I think to maybe paint the bigger picture on the whole cappers thing is we'll bring up Jason Cheezit. He's the Community Development Director, and he can explain the additional steps that are still necessary for that property to get back to what it was before, which I think is where some of the questions have come up from. So after the rezone, Jason, what else is necessary for this property to get back to functioning the way it had before?
Yep, no problem. Thank you, Mr. Witt, and good evening, members of the board. If the board elects not to appeal this, the property would be zoned C3 commercial. It was previously zoned C1 commercial, and C1 commercial is like the most restrictive commercial zoning classification that we have, and C3 is the least restrictive. That being said, even to open up the bar eatery that was currently on that 4.7 acre property, use the concerts, any tubing activities would be outside recreational facilities. That would all require separate conditional use permits, and that would go before the Board of Adjustment. And just to back up, when you are evaluating a conditional use, or what I call a CUP, the Board of Adjustment or the board deciding that can put conditions specific to that property. So maybe they identify some physical property features like wetlands, or of course the Apple River on this property, and they can require certain setbacks and certain performance standards to address each property individually for a proposed use. So that's something that would happen afterwards if the original development came through. I would also like to add to what Mr. Witt mentioned before. In April of 2023, the Planning Commission for the town approved of the request, and on May 3rd, the town board approved of it. And on May 18th, it was before our Community Development Committee, and at that time, there was no objections heard, and it was approved, and then that's what brought it up to the June 6th County Board action. And generally, when we're looking at any rezone request, like the one that you guys approved on the consent agenda tonight, there's really 4 criteria that we should really be evaluating. And this is what our staff does in-house and that before we take and bring it to the Community Development Committee. One is the existing land use. And I don't mean actually the land use itself, but that could be physical features of the property. So it might not make sense to put garbage disposal, landfill type of use and on a property that's surrounded by wetland, for example. So that's what I mean by existing land uses, what's going on site. Number 2 is surrounding land use. And so is the proposed use compatible with the other uses in the area so that it's not going to be a big public nuisance? Probably the most important, and I know that you guys are all familiar with this, is the future land use of the property. So how is the property identified in either the town and the county's comprehensive plan as what our 20-year goal is for that area? And then the last one, depending on the use, can be more significant than others, but it's public facilities, public improvements, infrastructure requirements that may be needed to serve that type of development. So something like a home-based business might be a totally different aspect than a gravel pit or a mine, as far as those infrastructure. This cappers use, it was determined, and that before it went to the CDC, that it did comply with the town of Somerset's comprehensive plan and the St. Croix County comprehensive plan. So with that, I can turn it over for any questions.
Any questions for Jason at this point?
Yes, Supervisor Ramberg.
I'm sorry, go ahead.
Thank you, Chair. So with the way it's zoned now, it still needs a conditional use permit for items like the concerts. Is that correct?
You are correct.
Other questions? Supervisor Adams.
Thank you. So if the property owner wanted to hold a concert, and that was a part of the income or the use of that property, and that was denied by permit, then, I mean, that could happen ad infinitum. Is that possible?
So are you saying that, like, are you trying to get at the definition of whether or not it's a bar or whether it's an outdoor entertainment facility?
I think I'm more concerned about the outdoor entertainment. I think it's what the residents are concerned about. That's what I'd be concerned about.
Yeah.
So could those permits never get approved, or what would be the condition for approval of those permits?
Sure, now I understand. So generally speaking, a conditional use permit is something that if the applicant and the county, in this case, agree to certain conditions, that you're able to customize conditions to minimize the negative impacts of that use. And then if there's a violation of any of those conditions on that conditional use, we could have a replay of September 2022, and that where our Board of Adjustment could revoke that conditional use permit because they had failed to comply. And then they're at ground zero and they have to start over for their plannings. So. Mm-hmm.
Other questions? Supervisor Counter.
Could you explain the difference between the current C1 zoning and the C3? What are the differences between the two? What additional things can happen in C3 versus C1?
As far as I know, in that it's mainly just uses. So there's more allowed or permitted uses in the C3 classification, and then there's more conditional uses. So there's just a bigger pool of potential uses on the property.
You have examples that, I mean, and just to say that, it doesn't really identify what I'm trying to get at for.
Yep. So just thinking, we have a use table. Trying to think of a good one. So what's that? Yeah. It's a big table, of uses, and it's all broken out because in each zoning classification, they've got permitted uses, conditional uses, prohibited uses, of course. And so some of the uses that are in the C3 zoning classification are permitted or allowed, and that without a public hearing, without the due process, and that versus in the C1, they'd be prohibited or they'd be a conditional use. So, but all kinds of uses. Some of the C3 classifications would be campgrounds, the outdoor entertainment, the bars, the restaurants, lodging facilities, typically motels and stuff would all be in the C3 category.
Supervisor Shirley?
Can you correct me if I'm wrong, but I believe that the local municipality requested that this get rezoned from C1 to C3. Is that correct?
Correct.
Supervisor Carlson?
What is Cappers wanting to gain, in his case, from going to C1 to C3? Is it the outdoor entertainment in the bar, or?
Yes, that's what I believe is the outdoor entertainment and the ability to go for the conditional use permit for it. So the applicant, Cappers in this case, did submit 3 conditional use permits to our office, and that back around that June time period. Our office had held on to them because it was lacking information. And then we just sent them back here about a month ago, but they would be able to reapply. So, yep. Yeah, so I'm sorry at that, but here Heather or Ken have up all the different uses. So you can see our C1 and our C3. For example, a caretaker unit is allowed in a C3 zoning classification, but not in a C1.
And specific to this case, a bar or tavern is a permitted use in C3, but is not allowed at all in C1.
So you can see here too, and that the outdoor entertainment and outdoor rec, and that the C3 allows for the outdoor rec, but it does not allow for the outdoor entertainment. Racetrack, skiing facilities are all, so that's where the C3 is just that bigger district that encompasses many more uses. So.
Any other questions for Jason at this point? I don't know if Corporation Counsel wants to make any additional comments.
I have no additional comments, but if anybody has any questions, I can try to answer those questions.
Supervisor Otino.
Thank you, Mr. Chair. My question is, I want a better understanding of the option here, yes and no. If you are in support of the decision that Judge Nordstrand made, and you want to stay that way, and then the property, am I correct, is rezoned to the C3, you want to say yes or you want to say no?
You want to say no. So the motion before the floor right now is a motion to appeal. Support appeal. So if you do not want to appeal the decision, you want it to stay rezoned at C3, agreeing with the judge's decision, then you would vote no. A yes vote would mean you want to appeal it, and you don't agree with Judge Nordstrand.
I'm having trouble with the way that's worded then. Number 2, no vote to appeal. A vote no can mean that you disagree with the judicial reason for the decision, but not the net outcome?
So it can mean that you disagree, and the second sentence is a no vote could also mean that you agree with the judicial decision and just want the property to be rezoned. So it could mean either thing. So we're not going to ask you to explain it, even though Judge Nordstrand may want you to.
So in order to support the decision that Judge Nordstrand came up with, you would vote no. Thank you very much for the clarification.
So at this point, okay, Supervisor Counter.
I think the biggest thing I have a issue over this isn't necessarily the decision that the county board made. I think the issue I have with this is when you take a legislative decision and then it's decided under the judicial branch to make decisions on behalf of the legislators. And my understanding of Constitution is that those are supposed to be kept totally separate. And I can understand if the judge would have sent it back for reevaluation or for other reasons that he felt that the decision was unjust. But to point blank change the outcome of a voting legislative branch seems to me to be a little over the top on where that would be acceptable. Maybe I'm wrong on this, but that's how I was kind of taught in about basic civics.
And that would be the basis of the appeal, is that this is a legislative body. You are making a legislative decision. So a rezoning is a change in the ordinance. And changes to ordinances and establishing ordinances is the sole discretion of the legislative body. And so court should give great deference to the judgment of the county board supervisors. And in this situation, my argument to the Court of Appeals would be that the judge, replaced the county board's judgment with his own. And so that would be my argument if we were to appeal. So you are accurate, Supervisor Counter, that that's the differentiation, is this is a legislative decision. It's not a decision of a quasi-judicial body like the Board of Adjustment, where there has to be findings and evidence and facts. Legislative decisions are in the discretion of the county board. So that's the difference.
Supervisor Shirley?
Question for court counsel. I believe that the state statute has changed so that we do not need a supermajority anymore. Do we need a supermajority on this vote?
No, this is just a simple majority.
Okay.
Any other questions or discussion? Is everyone pretty, okay, Supervisor Burning?
Do we have a copy of what Judge Nordstrand actually made the ruling on, not just a synopsis here in attached to a resolution?
The proposed order was just submitted by Attorney Jamie Johnson today, so it was too late to add it to the agenda packet. I can read it if you want to. It's about a page and a half. But basically, the important part would be the court findings.
Well, I would like to hear it, because that is actually what we're voting on, and not necessarily just a couple of paragraphs that were typed together. So I actually would. Oh, my wife's going to kill me. I actually would like to take a moment, like a brief recess, and I'd like to read it prior to taking a vote on this, because I don't think it's right for this body to take a vote based on just a synopsis of like one paragraph and saying this is what the judge said when we don't know what the judge actually said.
We could take a recess and make copies.
Yes, we'll make copies for everyone so everybody has an opportunity to read his decision, and then we'll reconvene in a couple minutes after we've gotten copies to everyone. Yes, everybody had a chance to review.
There's a private conversation going on over there.
Okay, so does anyone have any additional questions? And I'd say specifically for Corporation Counsel. Any other comments? Supervisor Shirley.
Okay, so thank you for getting this for us, by the way. The way that I read this is that the decision of the county board is arbitrary, oppressive, and unreasonable. That, in my mind, is because on the Community Development Committee, we followed the St. Croix County, now I'm losing my words, ordinances, and we passed it that way. And the vote here ignored the ordinances because they're following everything according to the letter of the law. That's the way I read this.
And I can tell you what Judge Nordstrand held at the hearing last week is he did not believe that there was enough evidence before the county board to support a denial. And what I explained to him is, but for the protest petitions, that may have been true, but the protest petitions that were filed 24 hours in advance of the hearing is what prompted some of the no votes because of the concerns of the adjacent property owners. So that's kind of the reason why, obviously, there was concerns between when this Community Development Committee was held and where the county board meeting was held is because of those protest petitions being filed.
I do understand that. I think that we have to walk tread a line on that between that and what our actual ordinances are. We have to follow what we've already set up that we said we're going to do. So if somebody buys a piece of property and we say that they can do this in our ordinances, and then we come before this body and we say, well, not in this case, that's a problem. So if we want to go back and talk about ordinances and things that we want to change, that's fine, but we need to follow what we have set up already.
Supervisor Connor?
Again, I get back just that, I'm not saying one way or another as far as what the outcome of how the county board's vote came. The county board's vote came the way it did. But the concern is in, again, coming back to the court case, and even in the example that's here that you have identified and given to us under the second paragraph in the top, he gives an example of a case where he felt, where that particular judge felt it was not in the interests of the, they didn't have the support. But his process was to send it back and remanded it back to the county board of supervisors for further action, which is totally different than to remand the decision of the county board. And so I know it's an extra step process, but I think it's a really bad precedent to allow the judicial side to remand the county board's decisions without sending it back to the county board to reevaluate.
Supervisor Van Summeren.
I would agree with what Scott says. We in good faith make our decisions, and I just don't think that it is correct for anyone who is not an elected official to change those positions. I mean, then any and every decision we make is up to whatever some lawyer sitting someplace thinks, and we could do nothing. We could be totally powerless, and I don't think that's the way that a board should work, and that's not the way the boards are set up to work. So I think we have to appeal this.
Excuse me. Supervisor Carlson.
His first sentence, no findings were articulated by the County Board of Supervisors detailing the decision. As far as I know, there's no requirement for us we vote all the time without each one of us 19 saying our decision so somebody can look later and say, oh, they didn't articulate it. If I understand it right, we don't have to articulate it. We take what we hear and we decide.
That is the exact argument I made before the court, is that there's no statutory requirement or ordinance requirement for the county board supervisors to articulate a yes or no vote. And I think the differences and what the judge relied on is arguments made by Mr. Capper's attorney that, you know, Mr. Capper should have been granted the chance to argue before the county board, that there should have been evidence, that there should have been findings, and those are all things that are required before the Board of Adjustment as a quasi-judicial body. It's not required for a legislative decision of this body. And as you indicated, you make decisions all the time without articulating why you're voting yes or no. And so this legislative body's decision should be given great deference, and the court should rely on that and not require these additional things when it's not required by statute.
Other questions or comments? Okay, before we do a roll call vote, I want to make sure that everyone is clear on what we're voting on and how we're voting. So this is a vote. The motion is to appeal the judge's decision. So if you vote yes, you're voting to appeal the decision. If you're voting no, the decision will not be appealed and the ruling will stand and the rezoning will take place. Okay, we're clear on that. Let's do a roll call vote. Oh, sorry. Supervisor Shirley?
I guess if we're going to go down the road of appeal, I would like it defined on what, I want it in the motion of what you're actually appealing, not the decision, but which way we're going on it.
And so I can tell you, so if it is decided to appeal, what I appeal is the decision of Judge Nordstrand to reverse the decision. And so Court of Appeals in certiorari review cases, they review the decision of the county board de novo. So they don't review what Judge Nordstrand did. They review the decision of this board de novo, so from scratch. So they will review whether or not the county board's decision was appropriate. They will not question what Judge Nordstrand did. They'll basically be reviewing the initial decision of this county board that happened on June 6th.
Supervisor Adams?
How long of a process is that, just out of curiosity?
That is a great question. So the appeal has to be filed within 30 days of the decision, and which is why we added it to this month's agenda. Between a briefing schedule and an actual decision, if it's a 3-panel decision of the Court of Appeals, I would say probably a year.
Okay, any final comments, questions? Mr. Supervisor Burning.
Yeah, thank you, Mr. Chair. So we're basically given 2 options here today. Are there more options than just these 2? Because the way I kind of look at this, and just based on yours and my conversation, Corporation Counsel, is there's literally things that that Mr. Cappers could do that would avoid this appeal anyway. And if we go to appeal, this would just extend the process. I mean, there just seems to be more than just these 2 options. Give me more options than these 2, please. That's what I'm asking for.
The information I provided to Mr. Capper's attorney is that there is no prohibition in the ordinance or the statutes preventing him from filing a new rezoning application. He could file a new rezoning application, and now the protest petition statute has been repealed. So if he were to file a new rezoning application, go before the town, obviously the town has the right to vote whether to approve or disapprove. But if they were to approve the rezone, this new application, then it would become back to the Board of Supervisors for a majority vote, because the protest petition statute is no longer in effect. It's been repealed. There is no ability for neighbors to require a supermajority. As Mr. Chizeth has indicated, Mr. Cappers did file the conditional use permits to have camping, outdoor entertainment, and the tubing, but he withdrew those applications pending the result of this rezoning case. So he can move forward with quite a few other things. It's just the bar that is the issue, because the bar or tavern is only allowed in C3. So there's nothing he can do to have a bar or tavern unless it is rezoned to C3. And if there's other items I'm missing that he may be able to do, I'm assuming that the community development director could fill in. But that's the one other option I gave to Mr. Capper's attorney.
Supervisor Carlson?
Thank you. I understood that if the town approved or disapproved, it still comes to us. Is that correct?
If the town disapproves the rezoning, the ordinance and the statute indicates that the county board must disapprove the rezoning. So if they were to have voted no, we don't support approval of the rezone, what the ordinance indicates is that the county board has to disapprove it.
Any other final comments, questions? Okay, is everyone clear on what we're voting on? Okay, let's go ahead with our roll call vote, please.
Supervisor Leaf?
No.
Chair Long?
No.
Supervisor Cook?
No.
Supervisor Adams?
No.
Supervisor Burning?
No.
Supervisor Attino?
No.
Vice Chair Fiedler?
No.
Supervisor Osnes?
No.
Supervisor Counter?
Yes.
Supervisor Shirley?
No.
I'm sorry.
No.
Supervisor Telejohn?
Abstain because I'm on the Board of Adjustments.
Supervisor Carlson?
No.
Supervisor Barkalow?
No.
Supervisor Swanepoel?
Yes.
Supervisor Van Summeren?
Yes.
And Supervisor Ramberg?
Yes.
It's 4-11 and 1.
So that was 11-4, so that resolution, or the motion passes. So we will not be appealing.
It fails.
I'm sorry. I'm sorry. The yes and no gets confused. The motion fails, so that was a vote not to appeal the judge's ruling, to be clear. Okay, thank you all for your thoughtful discussion on that. I really appreciate that. So move on to our second business and last business item, a resolution of commitment support for the Wisconsin Department of Transportation Transportation Alternatives Program application to construct the continuing the off-road trail phase 2. We would need a motion to approve.
I move.
Supervisor Leaf, and second, Supervisor Van Summeren. Yeah, would someone from Community Development like to brief us on this issue?
Thank you, Mr. Chair and members of the board. So what this resolution does is we had to submit for phase 2 of the Highway 35 bike and pedestrian trail. And phase 2 basically goes from old Highway 35 up to County Road V, crossed on River Road, and connects to the Will River State Park on the northwest corner of the park. Phase 3 would be something further on down the road that would connect there up to our Loop Trail property and the new Highway 36-64 bridge. But phase 2, for the TAP grant, there's no obligation for any financial contribution for this, and I do want to make sure that we do update that, because we had to submit our TAP grant application this year earlier than what it is normally. Usually it's the end of January, and now the deadline was the end of October. We had our bid opening on phase 1 of the trail on November 2nd, and those costs came in much higher than what we thought. And so the DOT was seeing that across a lot of their projects that they were getting bids on at that time. So they allowed us to take and add a supplemental bid number and that to basically include the inflation between now and 2027 building cost. And so really that $668,000 on our new submittal was 943,000, and the 20% county match would be around 189,000, 188.6. And so again, this doesn't, tie the county board and that to doing this project. It's basically showing the DOT that St. Croix County is committed and that to doing the cost share if everything comes together for our grant dollars and our bids are coming in at the right amount.
Questions? Supervisor Bamberg.
Thank you, Chair. I appreciate all the work that goes into this stuff. It's like herding cats after a while, I'm sure, because I've got experience with that. And just to be clear, and it does say it in here, that this is a 80% reimbursement program where we pay 100% of the costs and then we get reimbursed 80% after everything passes all the inspections and all the material tests and all that nonsense. But just so everybody's aware of that, and I'm in agreement with this. It's just that I want everybody to understand that we pay 100% and then get reimbursed. It's not like a regular grant where you get the money up front and then you get to spend it, on a project. This has got a lot more cats involved. Thank you.
Yeah, I will add that this Highway 35 trail segment here serves just over 200 houses in that are within a close area. And it was one of the goals or objectives identified in the 2017 Bike and Ped Plan that the county adopted. So we just had to make a choice, on that to apply or not. And but we wanted to at least throw our name in the hat. So the DOT, because St. Croix County has over 50,000 in population, they consider us in an urban pot for these TAP grant funds. And we got good news on this one here that they were going to actually put us in the rural pot because the town of St. Joe, of course, does not have the 50,000 population, which then would increase the county's ability or odds of getting that 80% cost share.
Thank you.
Okay, other questions? Oh, Supervisor Barkalow, sorry.
Yeah. So this is 4 years out. Is that the idea?
Yeah, like a 2027 build.
Okay. And then our best estimate is that it's going to be around almost $1 million by the time we get to it.
Well, we built in the inflation of 5% per year, and then also added some contingency in there. And so that's where we came up with that 943 figure.
Is this going to be using the shoulder, or is it going to be using like easements, or is it going to? Do you have a map of where this is going to go yet?
And I don't know if we had it in the packet.
Sorry, I didn't get to
but
the packet.
it is within the highway right-of-way of Highway 35. And then once it gets up to County Road V and the town road there, then it's just a painted bike lane on top of the existing asphalt because the road is wide enough to allow for that. So really the main construction is the vertical north-south part there. That'd be a 10-foot wide paved trail. And then it would be an on-road trail going over to Willow River State Park.
Wow.
Other questions, Supervisor Counter?
During the community development meeting, one of the things that we brought up was if there was any potential use on cost savings to do that as a crushed stone. Were you able to find any information on that?
Yes, so these TAP grants and that are required to be paved, and they are required to be wet construction or bidded out construction. And now, and that our existing TAP grant that we've got for the phase 1 does not allow us to have any other uses on it. It's basically bike and pedestrian. But since the infrastructure bill was passed and the BIL law went into place, new TAP grants, including phase 2 here, could have some potential on that of having snowmobile trails. So that's one of the things that they changed with the BIL law. So.
Okay, other Supervisor Otino.
I'm not sure I can say this or not, but I'm to a point where we spend money, and we spend money. And this is going to be well over $1 million. And if I remember reading it, it was not that very long of a extension to the trail. And I just don't, we've come to a point where, you know, we've spent the camper cabins, the millions of dollars to appease and make happy a very small group of people. This, again, would be a very small group of people that I can see utilizing that road. Number one, if you're out biking on 35, when they're whizzing by you at 65 miles an hour, God bless you. But I just think we're to a point where, with everything that's going on in the economy and in the world today, sometimes we just have to say no. Thank you for letting me rant.
Any other questions or comments? Supervisor Burning.
Thank you, Mr. Chair. So my question for you is, what is the possibility, since we're looking out like four-ish years for this project, this grant comes in, these are designated dollars that are used for these types of projects throughout the state and the country. I take it someone's going to get this money and use it to improve like the parks and the this type of infrastructure. So if we used it, what if we engaged our private, there's like 4 bike entities, bike and pedestrian entities that are really active in western Wisconsin. Is it possible, and can we explore the possibility of maybe seeing if they would be game to raise half of the 20% that we need to come up with and do a private infusion of dollars to help build this through fundraising or whatever? I mean, is that a possibility?
I don't believe that would be a possibility directly for this, but maybe there could be some amenities along the trail, like some benches or something that fundraising could be. But the TAP grant program requires a 20% local match of funding, which would be the county.
And you're saying local levied tax dollars from the county? Mm-hmm. I mean, is that like that is, or that's what we're thinking? Corp Counsel, what? I'm sorry, putting you on the spot, Pam.
I don't obviously know the parameters of this grant. However, in our rules, there are donation programs. So I suppose like Friends of the Park, if that was created, could donate money to the county to be used for parks purposes. But the money for this TAP grant would have to be paid by the county. And how those donations would work in terms of offsetting some of that, I don't know the specifics of financial.
We just need to verify. Yeah. I guess we wouldn't be able to 100% answer your question without a little more research. I understand what you're asking for, potentially, but I don't know what the definition of match means specifically.
Okay. I mean, because I know that my friend to the right of me, Supervisor Otino, brought up riding on highways at 65 miles an hour. That was me for 2 decades, biking 100 miles a week. And so anything like this that we can do to help keep bikers in a safer position with being on the highway, I think it is important. So I'd like to see, though, if we can engage our pedestrian and bike clubs and see if they'd be willing to do something, including but not limited to, and I brought this up before, helping maintain the trails. I mean, that's a cost to the county. I mean, we see these one-time dollars, but what we're not really realizing too is the ongoing expense of maintaining these, and that's manpower, of clearing debris, making sure that they're rideable. So I mean, there's just, every mile that you add is another hour-ish, another FTE point something. So that's where these clubs can come in and help. I mean, we got the libraries have their friends that are volunteer organizations that help deliver books or help, sort books. So why can't we get more engagement like that for stuff like this? Otherwise, we're just piling on the more. And I'm so for this too, but we're just piling on more obligation down the road for our taxpayers I agree with Supervisor Otino, but I also disagree with him at the same time. But I agree with him on the premise that we're just continuing to stockpile obligations and they just keep rising up. But
And, yeah, and from what I read in the bike and ped plan is that the county board knew this going ahead, that these trails were gonna take and cost money and that they were gonna have maintenance, and all of that needs to be figured out yet as far as, what's gonna be required for the maintenance and who's gonna be doing it, so.
I mean, so can we ask you, I mean, we're T-minus like 5 minutes to me getting in trouble here. So can we ask you to help engage the bike and ped groups in the area and see what their appetite is? I mean, I know if this was even a possibility back in the day for biking, I mean, I biked on the shoulder of the road with on Highway 65 with semis blowing by. I mean, that was not fun. No helmet too. That was the days of no helmet. Yeah. And no hands. You just, ride. But, so yeah, I mean, if we could ask you to help engage that, I mean, I think there's a really active, group that wants to engage, and now I think this is something that we can give them to stimulate that engagement. So
Yep, I'm willing to look into possibilities. And I want to be clear that this would be a completely off the road trail. It's within the right of way of the road, but it's not like it's just a wider shoulder on the road. It's a completely separate trail.
Other questions, comments? Is everyone comfortable with a voice vote on this particular issue? Any objections to that? Okay, so the resolution is to approve the resolution. The motion is to approve the resolution. All those in favor signify by saying aye.
Aye.
Any opposed? And that passes unanimously. Oh, sorry?
Two noes.
Two.
Excuse me.
Yep. Atino and
Okay.
Carlson.
Thank you. Supervisor Otino.
I'd like to repeat that. No.
Okay. And it was Supervisor Carlson. Thank you.
Those are the only two, right? All right, thank you.
Okay. Any requests for future agenda items? All right, seeing none. Any reports from the county clerk, correspondence? Otherwise, our next meeting, we will be having a meeting on January 2nd. Supervisor Otino?
One quick thing the judges didn't mention because Judge Nordstrand wasn't here himself. There is a treatment court graduation tomorrow morning at 8:30 a.m. and I encourage you all to attend. Thank you.
And I think that's more like 9 o'clock, but I'm not, around 9-ish. So it's always interesting any way you look at it. Otherwise, I hope everybody has a safe and wonderful holiday, and we'll see you back in January. Meeting is adjourned.